Following the Supreme Court ruling outlawing the trial of civilians in the court-martial last week, the president was one of those who condemned the judgment as unfortunate. However, in his statement, he also called for any amendments of the Constitution so that it can stop future judges from interfering with the useful self-protection instrument for the country and also remove any irrationalities, if any. These amendments are supposed to be presented to Parliament and moved by the Attorney General. But this has attracted mixed reactions from MPs.
So what is his interest? So because for him is pushing something to go his way, he wants the Attorney General to push that one very fast. To me, I have many questions there. Why of all military courts? And then he should swallow his pie. As simple as that. And the country will run as that. Let him try his military men, because they volunteered to go in UPDF.
Parliament has no powers to make what is illegal into legal. Parliament can only make laws for good governance and for the good order and development of the country. These laws are for Ugandans, but not members of Parliament.
However, some argue that if the amendment is intended to protect the interests of the national security, they would welcome the rally by the president.
Sure that the court-martial is formalized and it can also have the human resource that have a background in the law and can be able to handle court matters. I think that lacuna, if it can be resolved, I don't see anything wrong with the court-martial handling serious criminal cases that can affect the peace and stability of this country.
This Constitution of the Republic of Uganda, the 1995 Constitution, it was not made on stone. It was made on papers. The means can be amended. There has been piecemeal amendment of the Constitution. We need now a comprehensive amendment of the Constitution of the Republic of Uganda.
Some MPs say the independence of the judiciary is the one being challenged by the executive.
Museveni versus the Constitution. It is now Museveni versus Uganda. That Ugandans who are for the Constitution are now in court with Museveni on how to govern this country, which is really a shame. But Honorable Winyidoro is the one who saved him in one of the presidential petitions. He was his lawyer. Why did he say, this is a foreign-oriented lawyer, I will not even hire him? The independence of judiciary means that whatever they have ruled or they have judged, we just go by that. If you have a reason to appeal, you appeal. If you have nothing, you rest your case.
Expect to see any member of Parliament that will front these amendments on the floor of Parliament, because it will be an abuse into the independent arm of judiciary.
After the Supreme Court ruling, some say that the court-martial itself should be declared an illegal outfit because of its composition.
Even the UPDF Act itself has no proper procedures on how these judges are elected.
No, as it is now, the Supreme Court has decided on the matter, and we have to go by that because we respect courts of law and the rule of law.
It remains to be seen when the Attorney General will present the amendments to Parliament. Juma Kiria, NTV.